tell Molly to do it.
Yep.
I'll do it. I don't care. Okay, colleagues and friends, I pound the gavel to indicate that the Oregon Government Ethics Commission is now back in session. We are starting the public session as I speak. We are welcoming folks into our room as well as online. Let me just make sure that we have attendance roster up to speed. So, colleagues.
Yes, Molly will do the roll call.
Molly, please do a roll call. Thank you.
Commissioner Mettler,
Aye.
Commissioner McCulley,
I'm here.
Commissioner Burke,
Present.
Commissioner Thompson.
Here.
Commissioner Payne,
Here.
Commissioner Helt.
I don't believe Commissioner Helt is online at the moment.
Commissioner Hill will be back toward 1 o'clock or so. She said she had an obligation to attend to, so she'll be back at some point. And I'm here.
Thank you. There you go, Chair Fiscom.
The I'm here is your eminent chair. That's me, in case you didn't know. Okay, colleagues, welcome back after lunch. Let me tell you what the approach is going to be for the next while as we start our public session. We're going to begin with items on your agenda, public session agenda, items 12 through 19 involving the city of Salem. Our approach in this matter is going to be here first, a report from our investigator who will merge comments in some way that he chooses with regard to all of these matters before us. Then we will have questions for our investigator possibly, and then we'll allow those in the room who have come to us, as well as at least one person online, to make comments to us about this issue as it affects them. After those comments, we may have questions for the respondents, friendly questions, but nonetheless questions. And then after that, finally, we'll move to a decision on these matters. By the way, that decision will be made individually on each of the items 12 and 15. Frankly, we thought it made more sense to get everything out on the table before we decide anything. So that's going to be our approach today, and that's the rationale for it. So that said, colleagues, any questions or comments on that approach? I'll assume you agree with it unless you tell me no. Okay, the first step in our procedure was to ask our investigator, Mr. Sullivan, to make a report on these matters before us. Please proceed.
Yes, thank you, Chair Fiscom and Commission. This is Investigator Josh Sullivan for the record. First, I'm presenting agenda item number 12, the case with Mayor Julie Hoy. Please bear with me as we've made some last minute changes to consolidating these just so we get all the information out there for your consideration. So I'm going to, after I finish presenting this meeting summary, I'm going to continue with some of the information from the other meeting summaries. So this is a public meetings law complaint against Salem Mayor Julie Hoy and the other members of the Salem City Council. The complaint in this case alleges that Julie Hoy had individual conversations with a majority of the city councilors discussing whether Keith Staley should be asked to resign from his position as city manager, and that these communications occurred outside of a public meeting. Oregon administrative rules prohibit serial communications among a quorum of a governing body members, stating a quorum of members of a governing body shall not, outside of a meeting conducted in compliance with public meetings laws, use a series of communications of any kind, directly or through intermediaries, for the purpose of deliberating or deciding on any matter that is within the jurisdiction of the governing body. The information in this investigation indicates that between February 1st and February 7th, 2025, Mayor Julie Hoy had a series of individual conversations with the majority of the city council through text messages, phone calls, and in-person meetings. These conversations included discussions about the city's leadership audit, Keith Staley's performance, and his continued employment with the city, each of which is a topic within the jurisdiction of the city council. Mayor Julie Hoy gathered and weighed the information from her communications to determine that a majority of the city council was in favor of Keith Staley's resignation, and she shared this determination with the multiple members of the city council, including Council President Linda Nishioka, who then informed Keith Staley that a majority of the councilors wanted him to resign and asked him to consider submitting a letter of resignation. When Mayor Julie Hoy had a series of private conversations with a quorum of governing body members to deliberate toward a decision, these conversations constituted a meeting, and she acted as an intermediary through whom the city council convened. Additionally, as the private communications were part of the governing body's decision-making process and deliberations on matters within their jurisdiction, these communications constituted a meet in private in violation of public meetings law. When the city council convened through an intermediary outside of public meetings, they did not publicly notice these meetings or make them available to the public, nor did they provide minutes or recordings of these meetings. The recommendation is that the Oregon Government Ethics Commission should make a preliminary finding that Julie Hoy violated the provisions of Oregon Public Meetings Law. The individual citations I'll skip for now, and order that this case be moved to a contested case proceeding or that a negotiated settlement be entered. In the next case, in Paul Tigan's case, as discussed previously, it's a complaint that a majority of the city councilors had a series of conversations discussing whether Keith Staley should be asked to resign from his position as city councilor, and that those conversations occurred outside of a public meeting. In his case, he received a phone call from Julie Hoy on February 1st, during which she informed him that it may be time for the city manager to go, and he stated that he did not have an opinion. On February 3rd, he had a conversation with Linda Nishioka, informing her about his conversation with Julie Hoy, saying that he had not formed an opinion, but admitted that the timing was poor. On February 12th, he exchanged text messages with Mickey Varney, and they discussed a draft statement for this councilors to consider using as a public response to Keith Staley's resignation. And in that conversation, he discussed Staley's severance, the effects on the upcoming city levy, and seeking advice from the city attorney. In the following case, in Linda Nishioka's case, she discussed the city's leadership audit with Julie Hoy on February 6th, and Julie Hoy informed her that a majority of the city council wanted Keith Staley to resign. On February 7th, Linda Nishioka met with Keith Staley and asked him to consider submitting a letter of resignation. After Keith Staley's resignation, Linda Nishioka had several conversations with other city councilors about the matter via text messages and phone calls. She exchanged text messages with Mickey Varney discussing the possibility of placing Keith Staley on administrative leave and conducting an investigation. And she had conversations with Vanessa Nordyke and Deanna Gwynn about what had occurred and how to proceed. All of these conversations were matters within the jurisdiction of the city council. In Deanna Gwynn's case, she had a conversation with Julie Hoy on February 1st and February 6th about the between February 1st and February 6th about the leadership audit and Keith Staley's performance as city manager. Gwynn stated that she expressed her surprise but did not give her opinion on the matter. On February 11th, Deanna Gwynn and Mickey Varney spoke on the phone. Deanna Gwynn stated that Julie Hoy informed her that she had called the other city councilors and the majority of the city council had agreed about Keith Staley's departure from his role as city manager. And then in Vanessa Nordyke's case, she met with Julie Hoy in person on February 3rd to speak about the city's leadership audit and Keith Staley's performance as city manager. During the conversation, Julie Hoy expressed that she wanted Keith Staley to resign, and Vanessa Nordyke stated that she did not believe the resignation was necessary. She suggested postponing any action until after the election. On February 10th, Vanessa Nordyke exchanged text messages with Linda Nishioka and stated that she did not support the decision, and she suggested planning an executive session to discuss the matter. And then on February 10th, she had a conversation with Mickey Varney and shared what she planned to discuss in the executive session. On February 11th, she exchanged messages with Linda Nishioka, concentrating on the upcoming city levy and not on possible litigation on the matter. In Mickey Varney's case, she spoke with Julie Hoy on February 2nd about the city's leadership audit and Keith Staley's performance as city manager. And they discussed placing him on administrative leave while working toward a decision. On February 10th, Mickey Varney discussed Keith Staley's resignation and alternate ways to resolve the matter, such as an investigation. They discussed the effects of the resignation, the effects and what they could have on the upcoming levy and possible resignation. And she had a conversation with Vanessa Nordyke, who told her that what she planned to do in the executive session about the matter. Mickey Varney drafted a public statement for the city councilors to consider releasing, and she shared and discussed the statement with Linda Nishioka and Paul Tigan. The communication among the city councilors, including Julie Hoy, constitute a quorum of the governing body engaging in discussions or communications that are part of the governing body's decision-making process on matters within the authority of the governing body. And the city councilors participated in the unauthorized deliberations when the Salem City Council conducted a meet in private. Their communications constituted a meeting as a quorum of the city council convened through Julie Hoy as an intermediary in order to deliberate toward a decision about Keith Staley's resignation. As these deliberations did not occur in a public meeting, they participated in the prohibited serial communications. In these cases, the recommendation is to make a preliminary finding of violations.
Before we move on, do you want to address the other two?
Yes, and then there are two cases where we are not recommending making a preliminary finding of violations. These two are city councilors Irvin Brown and Shane Matthews. As discussed in the earlier cases, the complaint is about their discussions about Keith Staley and the upcoming audit, and their conversations related to his performance and ongoing employment with the city. In investigation, we examined the individual councilors' involvement to identify whether their participation constituted a violation of public meetings law. The information in this investigation indicates that although a quorum of the city councilors engaged in communications that were part of the governing body's decision-making process on matters within the authority of the city council, it does not appear that Shane Matthews or Irvin Brown participated in the unauthorized deliberations when the Salem City Council conducted a meeting in private, nor does the information support a finding that they participated in a prohibited serial communications with the other councilors. And the recommendation in those two cases is to dismiss.
Thank you, Investigator Sullivan. Appreciate it. The next step of the process allows us as commissioners to ask any questions of our investigator if we have such questions. And I'm looking around the room and online to see if there are questions. If you don't ask them now, there'll be time later. But are there any questions for Mr. Sullivan right now before we forge ahead? Based on what you've read in advance and or what Mr. Sullivan just said. So thank you, Investigator. Okay, the approach from here is as follows. One, we're going to ask respondents to testify before us in the order in which their names appear on my schedule, which is, there's no magic answer here. After each of you testify to us, by the way, we want to strike the right balance in this process of asking you to be as brief as possible while you hit the high points of your comments. At the same time, we want to make sure that we do you the courtesy, we'll honor this, of giving you time to speak to us in person online, because we value those personal comments from you. After each of you speaks, if there's a question or question or two that somebody wants to ask of you, we'll allow that to occur. But at the end, there may be a general question and answer period for our investigator, as well as for the collection of you representing the city of Salem. So that's kind of the approach that I would intend to proceed through for the next while. So in order on my agenda, the first person to speak is either Ms. Gibson, who's online right now, or Mayor Hoy. Ms. Gibson, this is your time to speak to us. We'll look forward to what you have to say. And I now see Ms. Hoy is also online, so please speak in any order you choose. Please speak in any order you choose. And as you do, identify yourself for the record. Please proceed. Thank you for being here.
Thank you. I'd like to go ahead and go first if my attorney's okay with that.
Please, Mayor, I'm okay. If she's okay, she's nodding her head yes. Please proceed.
Great, thank you. Back in January, the city attorney's instructions to me were to contact each counselor individually, ask if they had read the audit report, and let them know we may need to discuss the city manager's possible resignation. From the city attorney, I heard loud and clear that it would be a violation to ask people how they feel about the matter and/or to count votes. I made those individual calls. I stated the purpose for those calls and told each counselor I couldn't ask how they felt about the matter and was not calling to count votes. I told them I wanted them to be aware, to read the audit, and to be ready to discuss the matter further. The last call I made was to Counselor Nishioka, in which I relayed the same message. On that call, she asked if I thought I had enough votes. I told her the same thing I told everyone else. I am not calling to count votes. I cannot count votes, and that would be wrong. It was from there that things devolved. The city attorney called later that day to tell me that Counselor Nishioka wanted to discuss the situation with the city manager on her own. I asked if she could do that, and the city attorney said anyone can have a conversation with the city manager. I asked Linda the next morning if she wanted me to attend the meeting with her, and she said no, that she wanted to speak to the city manager, someone she cares about, by herself. I followed the rules, and based on the instructions and guardrails provided by the city attorney, I had done my part, and I had done it right. I heard from the city attorney later that afternoon. He told me the meeting had taken place and the city manager wanted the weekend to think about it. By Sunday afternoon, the city manager had emptied his office and he was gone. I was genuinely surprised by his sudden decision. The truth is, Counselor Nishioka went ahead of council on this by inserting herself into the matter. I have no way of knowing what was said in that meeting, and I believe it was in the aftermath that she lied to protect herself. We could have followed the process and landed in an executive session or council meeting to discuss the matter. Instead, he was gone, and we were all left to sort things out. My version of events has remained the same. It is the truth. I followed the rules, and based on the instructions and guardrails provided by the city attorney, I did my part, and I did it right. Effective January 1st of this year, this commission was required by law to prepare and provide training on matters such as these. I did not receive that training until April. And some say that training lacked perfection. In my role as an elected official, I take ethics very seriously. Basing this investigation's findings on one person's version of events over another is wrong. There is no evidence to corroborate Council Nishioka's claim that I told her I had enough votes. That is simply not true. Thank you for the opportunity to testify before you. You may know this investigation is being used by certain members of the public to do harm. I'm looking forward to moving on from this and learning from your letter of education. Thank you.
Thank you, Mayor. Let me just hold off on questions for you that my colleagues might have and allow first your counsel, Jill Gibson, to make any comments she chooses to make to us. Ms. Gibson, if you are ready to speak, please proceed. Ms. Gibson, you may be on mute. We can't hear you, so say your name out loud once and we'll see if we can. You're on mute. You're off mute now, so let's see if we can hear you. Ms. Gibson, we still can't hear you. You're back on mute. Still can't hear you. If you want to try again, one approach would be for us to move on to other respondents and see if you can, with help from some persons, including us, fix your system so we can hear you speak, because at the moment, we're not able to hear you, even though I can see you're trying to talk with us, so
Chair, can I make a recommendation that,
Please.
Can you hear me now?
there we go. Yes.
please, Ms. Gibson, please proceed. We can hear you now. Maybe?
Can you hear me now?
Yes,
You can?
Yes.
yes, a little disruption, but utter a sentence or two to start, and we'll see if we can hear all those words.
Okay, I'm having trouble hearing you.
So, technology goes both ways.
I'm going to connect by phone.
Okay, let's go ahead and try to do that with our staff's help in the next moments. And meanwhile, we'll go on and hear from the next person, and then we'll end up getting back to Ms. Gibson in a few moments. So Paul Tigan, please, this is your time. Thank you for being here. Identify yourself for the record and make your comments to us. Thank you.
Good afternoon, Paul Tigan, Ward 1 City Councilor. Members of the commission, thank you for the opportunity to speak today. I'll keep my remarks very brief. I respect Oregon's public meeting law and the principle that public business should be conducted in public. In this matter, as we've heard from the investigator, I do not believe that my actions, which are generally represented fairly in the investigator's report, support the conclusion that I participated in a quorum that reached a decision outside the public view. I appreciate the additional guidance the commission published in July. I have it here, cleared up a number of questions we had after.
That Q&A document.
Yes.
Thank you for that.
That was a very educational document, I think, to elected leaders around the state, especially us. And I look forward to continued guidance from the commission on how to act in these matters, especially when it comes to intermediaries, drawing people into conversations that, unbeknownst to them, turn into serial meetings in the days following. So thank you.
Mr. Tigan, thank you. Just a pause there for a moment, and we'll see if in light of what you said, and thank you for your appearance today and your patience with our schedule. But do you have any quick questions for the counselor before we forge ahead? If so, now's a good time. If not, Mr. Tigan will stay around for a while and be able with others to answer questions. So again, thank you for being here.
Thank you.
Appreciate it. We'll turn next to Linda Nishioka, if I'm saying that right. Linda, please help me with that.
That is correct. Thank you.
And we'll catch up with Jill Gibson in a few moments as soon as we find out that she's on the phone. So Ms. Nishioka, please proceed. Identify yourself for the record, and we're happy you're here today. Thank you.
Thank you very much. I am Linda Nishioka, City Councilor, Ward 2, and currently Council President. I already have sent you my statement, but I'll go ahead and read it as I understand that people don't have it. As others have addressed, thank you for the opportunity to address you, and I do respect all that you are doing, and I know that this is very difficult for you as well, interpreting and enforcing the new regulations that have come out since October 24. I'm going to say that if the commission finds that my actions, specifically accepting a phone call from Mayor after she had spoken with other councilors, constituted a participation in a serial meeting, I will accept a letter of education. It was never my intention to circumvent Oregon Public Meetings Law by accepting this call, and if that's if that's what you feel needs to be done, then I will accept this as a genuine and painful learning experience. To be clear, I really do want to say that I did not solicit or engage in any cooperative deliberation towards a decision with counselors regarding Mr. Staley's evaluation or employment. And in fact, to make a comment to Mayor Hoyes saying that I asked what the votes were, I did not. I simply, when she stated that she'd spoken with everyone and that I she either used the word majority or most, all counselors felt that he should resign. I replied with all of them, and her answer was, I am still waiting for one fallback. So we did not discuss votes. We did not discuss the merits of the audit. We simply were on the phone, and she shared that that was what the other counselors had told her. So I really feel there was a misdirection in her stating that I had lied, because I did not. I cared about Mr. Staley, and there were personal things in his life that if he was in a situation of needing to resign, that could really impact his family. And so when I heard this devastating news, I shared that with him in our scheduled meeting. And that was not an unusual topic for us to discuss, because he was already struggling with communicating with the mayor. And on the many meetings we had, I asked him how he was doing. And often he would say that he may have to resign earlier than he intended when he took the position. So it was something that we did talk about. This was not new news in the sense of our discussions in the past. But what was new is that I had been told that other counselors might be feeling that way. So I feel that that is very important for you to know. And at the same time, I don't want you to think it's she said, because that must be very frustrating for all of you. So I just want you to know that that's the situation we're in. And I also feel that the post calls and text messages that came after we accepted Mr. Staley's resignation were more about everyone trying to understand what happened. And it was really not deliberating on that, in my opinion. It was just like trying to understand, how did this happen? With all of that said, I'm committed to transparency and open deliberation in public and full compliance with the law. And I appreciate the guidance that you provide us. Thank you. And
Chair, thank you very much for your comments. Any quick questions for the chair of the council? Now's the time if you have any. Okay, can you stay around for a few moments until we reach the end, and there may be further questions you could help with? Thank you very much. Is Ms. Gibson online yet? Ms. Gibson, can you hear me?
Chair, we're still working on it.
Okay,
Just give us a moment.
thank you. We'll forge ahead. Thank you for your comment, staff. We will now hear from Deanna Gwynn, please, if she's in the room.
She's on the phone. Yeah, it's on the phone.
Oh, Deanna's on the phone. Deanna, are you on the phone?
She needs to hit *6 to unmute.
Please hit *6 to unmute Ms. Gwynn. Deanna Gwynn, can you hear me?
I think she did express having some trouble connecting last time she was here trying to connect.
Okay, well, let's try to catch up with her in a moment, unless she's online right now. Ms. Gwynn, can you hear me?
We should check the number.
Chair,
Please.
we have someone who's joined the meeting from a number we don't recognize that may be Jill. So can we we're going to give her permissions to speak so we can check and see.
Please
who
do.
it is.
Thank you.
And the caller calling in with the number ending in 9175, please identify yourself for the record.
This is Jill Gibson. Can you hear me?
Yes. Yes, we can.
That Jill?
Okay.
Ms. Gibson, can you say your name once for the record to see if we can actually hear you again? Thank you for your patience.
Jill Gibson.
Thank you. Okay, let's just go back to Ms. Gibson now. Ms. Gibson is the attorney for the mayor, Julie Hoy, and we've had some difficulty connecting with her, and now I think we've succeeded. So, Ms. Gibson, this is your chance to make any comments to us you choose to make. Understand that we're going to listen to most of the people from the city of Salem, including you, who testify at some point along the way. We may have questions for you. So thank you for being here, and thank you for your patience with technology. Please proceed.
Thank you, and I apologize for my technical difficulties I'm having. I first want to say that I do dispute some of Investigator Sullivan's characterizations of the witness statements, but I don't know if I'm going to have time to discuss those. I might at the end, but I'm going to just focus on my top 3 objections that I have to the investigative report. I've read all the counselors' witness statements, and not a single one states that they gave their opinion on the issue of whether or not to ask for Mr. Staley's resignation to Mayor Hoy. There can be no deliberation on this issue if they don't share their opinions. Still, Linda Nishioka does testify, and she alleges that Mayor Hoy told her that a majority of the council would like Mr. Staley to resign. This is the only counselor that makes this statement in her witness statement and supports the findings of the investigative report. And there are a couple problems with basing the findings on her allegations alone. First, the statement that she attributes to Ms. Hoy is hearsay, and there's no evidence that a single counselor told Mayor Hoy they thought Mr. Staley should resign, much less that a quorum told her that. Second, the issue before the commission is not whether Mayor Hoy said that a majority wants him to resign. Even if she did say that, that does not constitute a serial meeting. A violation does not occur by saying you had a serial meeting. It occurs by actually having the serial meeting. And in order to find that a serial meeting did occur, you have to determine, I believe this council has to determine, the commission has to determine that every counselor is being dishonest when they say they did not give their opinion or deliberate on the matter. But the report does not say which counselors are being untruthful. I don't think it's good enough to just say a quorum deliberated. I think the report needs to clarify which counselors deliberated, and that is missing from the report. The report simply concludes that there was deliberation because Mayor Hoy gave her opinion on the matter to counselors, but that's not enough to find a violation. In Handy versus Lane County, the case in front of the Oregon Supreme Court, the court stated that the passive receipt of another's views does not establish deliberation. The court stated, quote, without something more, a commissioner's mere receipt of the administrator's views on the matter is not sufficient to permit a reasonable inference that the commissioner decided or deliberated towards deciding that issue. That's on page 625 of that decision. And that's the situation we have here. Simply receiving phone calls from the mayor, even if she expressed her feelings on the matter, does not show deliberation pursuant to the analysis that the Oregon Supreme Court used in Handy. My second objection to the report is that there's no evidence that a quorum is required for asking for the city manager's resignation. The report seems to assume that a quorum is needed, but that's a vital piece of information that hasn't been established. There can't be a finding that a meeting occurred until it is established that a quorum is needed. This issue was raised in Handy, and the court affirmed the Court of Appeals decision that the public meetings law only applies to decisions that require a vote of a quorum. In Handy, because the decision to hold an emergency meeting did not require a vote of a quorum, there was no violation. The court stated, quote, even if a quorum of the Lane County Commissioners had met privately to decide whether to hold an emergency meeting, doing so would not violate the public meetings law. That's at page 654 of that decision. I've reviewed the city charter, Salem City Charter, section 23, excuse me. It regards city manager employment, and only the council can fire the city manager, but it appears that anyone can ask for his resignation. Therefore, any private conversation to discuss asking for his resignation is not a meeting because a quorum is not required. Now, pursuant to Mr. Staley's employment contract he had with the city, if a majority of the council asked for his resignation, then the city manager gets additional retirement benefits compared to if he resigns without being asked by a majority. But the fact remains that a quorum is not required to ask for his resignation. I have one more quick point, but I see that I'm out of time.
Make your last point as quickly as you can, Ms. Gibson, and we'll proceed. Thank you
Okay.
for your patience for recognizing our schedule.
Thank you. My third objection is to the report is that it views serial meeting very broadly and in a way that will hinder all public officials from performing their duties. The public meetings law does not require that public officials operate in a vacuum. Ms. Hoy reached out to the counselors to let them know that the performance audit existed. She encouraged the counselors to read the audit, and she let them know that the council may need to take action against the city manager. It seems to me that this is essentially how this commission operates. Before you come to meetings, I'm assuming you've been encouraged to read the report. You need to take action.
Ms. Gibson, we're losing you a little bit in terms of sound.
Okay. My point is that this commission operates in the same way as what Julie Hoy was trying to do by letting the counselors know that an audit existed, that they need to read the audit because they might need to take action against the city manager. This commission also receives reports, is encouraged to read reports before public meetings are convened. And that's not violating the public records law. Even if there are communications with staff related to those reports, as long as there's no deliberation, as long as opinions are not shared regarding what the vote should be, that does not violate the public records law. So for those reasons, I'm asking the commission to find that no serial meeting occurred.
Thank you, Ms. Gibson. We surmounted technology, I think. Your comments have prompted me to have a couple questions. I'm going to hold off on those. Anybody else have a question for Mayor Hoy's counselor? Hearing and seeing none, let's forge ahead with other testimony before we open it up for general questions. The next testifier from the city of Salem is supposed to be Deanna Gwynn. Deanna, are you online in a way you can hear me?
Hold on just a second.
Thank you.
She's on the phone.
She's on the phone and she does have permissions to unmute herself. She needs to hit *6 on her phone.
Deanna Gwynn, hit *6.
Chair Fiscom, I did just send her the direct link to join via Teams, so she's trying to do that on her phone right now, so
Fair enough.
she gets in.
Okay, let's just forge ahead.
She actually did just join.
Ms. Gwynn, can you hear me?
Hold
But
on.
just one moment, we need to be able to give her
That's fine.
permission. And
Deanna
Commissioner
Gwynn?
Halt has rejoined the meeting.
Thank you. Commissioner Health, welcome back. If you can hear me, thank you for coming back with us. Ms. Gwynn, can you hear me? Okay, let's keep working on that and we'll forge ahead. The next person who asked to testify was Vanessa Nordyke via Teams. Ms. Nordyke, can you hear me?
Yes, I can, Commissioner.
Thank you much. We can see you now. So if you didn't hear earlier, our approach is to hear comments from you and your colleagues. We may have quick questions, but we'll hold questions till the end. Please proceed and hit the high points of your comments. Thank you for being here.
Thank you so much, Commissioners, and I hope you had an opportunity to read my written statement. I actually think that the attorney, Ms. Gibson, had some good points to make, and that will abbreviate some of my comments here. I also want to echo the comments by my other colleagues that we appreciate all of the additional education and trainings that you have provided us. Unfortunately, a lot of that information happened after the fateful events happened. So as you know, there's really no dispute that I personally did not speak to a quorum of individuals. I had one conversation with the mayor of Salem before the city manager submitted his resignation letter on February 9. And so in order for this commission to find by preponderance of the evidence that I participated in a quorum of deliberations really requires an interpretation of your statute 192630 that is contrary to that Handy case that Ms. Gibson mentioned. I found that case as well, and I think that it is really instructive for this body. That was a case where all members of the governing body received an email from their county administrator that didn't just give information about a matter within their authority, but also expressed her opinion on whether to and how to vote on it. And the fact that each commissioner received this communication and even received the person's opinion was not enough to trigger a deliberation in the Supreme Court's view. So what the court did is it analyzed specifically, not through paraphrasing, but through what exactly did each commissioner say or do in response. And that is where I think the case falls apart against myself, and frankly, it appears to be several other counselors. You see, how we respond when someone like the mayor or an intermediary talks to us, it matters to us. It's not enough to just count heads. So as you know, commissioners, between February 1 and 6, the mayor reached out to every counselor. And I think it's important to note that who initiated these conversations is important, and it was the mayor. Each counselor has engaged in conversations with your investigator, and those reports are before you, commissioners. And I concur with Ms. Gibson that not one counselor told Mayor Hoy that they wanted the city manager to resign. I agree that if you're telling the mayor or any member of council or an intermediary that I don't have an opinion, I don't have enough information to form an opinion, or you haven't given me a sufficient basis to form an opinion, that is not a deliberation under Oregon law. So let's look at some of the examples. For example, this commission's investigator has found that when Councilor Matthews spoke to Mayor Hoy, he expressed no opinion. And I don't see how that is materially different than how any number of other counselors responded too. I reviewed some other investigative reports. Councilor Gwynn said she didn't give an opinion on the matter. Councilor Teigen said, I don't have an opinion one way or the other. Councilor Varney told Mayor Hoy, I felt I needed additional information before I could make any kind of decision regarding Keith. Councilor Brown did not give an opinion. And then as for me, I did not feel I had enough information to give an opinion on his employment. And the mayor didn't give me sufficient basis to agree with her that Keith warranted the highest level of discipline, which of course is getting rid of him. So commissioners, on these reports before you, none of the counselors that I saw, any of the ones that I just mentioned, none of them said they had enough information to request the city manager's resignation. No one expressed interest in exploring whether to end it. No one said they were ready to start deliberations about the city manager's employment. And as you know, commissioners, there must be some evidence of coordination or orchestration or other indicia of a purpose to deliberate outside of the public eye. And I'm not seeing that for myself or several of my colleagues for that matter. And my case is stronger for two additional points. Number one, I told the mayor we should postpone doing anything about this until after the May election. We had a big election in May, not for us personally, but it was a revenue raising measure. It was going to be a really close call. And if we lost that election, we would have to lay off dozens of members of staff. And so when I told the mayor, let's postpone doing anything about that, this is proof of me not wanting to start deliberations. This is proof of me telling the mayor that now was not the time to be deliberating Keith's resignation. The second key fact, and I brought this up with the commission at our last hearing, the mayor told me she wanted to keep our conversation between us. And I readily agreed to that because you know what that is? That's not a quorum, and that's not an intention to form a quorum. This is proof that I did not agree to the mayor speaking to any other member of council. This is proof that I did not agree to the mayor serving as my intermediary to speak to other counselors. Mayor Hoy, as we know, she ended up speaking with every member of council, and that was without my knowledge. Mayor Hoy and I had spoken in private many times before February 3rd, and it was not reasonably foreseeable that she would break my trust. And as you know, reasonable foreseeability is one of the exceptions to 192630. And there's no dispute in this record that I could find, and because this is the truth, I didn't speak to anybody about this between February 3rd and the city manager's resignation on February 9. I did not participate in a quorum of deliberations toward a decision of requesting the city manager's resignation. This commission should find there is not a preponderance of the evidence in this case to find that I violated the law. Thank you.
Thank you, Ms. Nordike. Colleagues, any quick questions for the commission, the council member before we head for two more discussions at least? Any questions quickly? Hearing and seeing none, we have a couple more, maybe three more to testify. First of all, I want to see if Deanna Gwynn is online in any way, shape, or form as I ask that question. Ms. Gwynn, if you're there, can you speak up?
I believe that I am now unmuted.
I believe you are now unmuted, Ms. Gwynn. Thank you for your appearance today and for your patience with technology. Please proceed to make any comments you choose to make. Identify yourself for the record. Thank you for being here.
So my name is Deanna Gwynn, Salem City Councilor, Ward 4, and I do appreciate the opportunity to address the commission. So thank you. I think that my colleagues have said it best. I don't believe that we participated in a serial meeting. I do want to say that my colleagues and I have worked diligently to foster a culture of respect, empathy, and thoughtful dialogue. And I remain committed to those values and to maintaining the trust and integrity that our community expects from its elected officials. So I will honor and respect the decision of the commission, but I really do not believe that any of us are guilty of what has been said.
Thank you, Ms. Gwynn. Any questions for Ms. Gwynn before we move ahead quickly? Hearing and seeing none, we have one more counselor in the room, Mickey Varney. Ms. Varney, this is your chance to make any comments you choose to make to us. Come to the witness table, identify yourself for the record, and please proceed.
Thank you very much. Chair Fiscom and members of the commission, my name is Mickey Varney. I've been a Salem City Councilor for 3.5 years, and I represent West Salem, Ward 8. Thanks for the opportunity to speak today. I believe as representatives of the city of Salem, we city councilors serve as role models for our community. People look up to us for direction, inspiration, and integrity. It's our duty to uphold the highest standards of transparency and ethical conduct, demonstrating that we are not only accountable to our constituents, but also those that we stand for. Standing up for my beliefs and values is paramount to who I am. Regarding the investigation we're here for today, it was never my intent to go around anyone or avoid any procedure or violate any laws. When the mayor and I talked on the phone on February 2nd, I truly did not know at that time that I was violating the law and participating in a serial meeting. Mayor Hoy reached out to me via text, first on January 31st, then on February 1st, and we finally talked on February 2nd. When I picked up the phone, I had no idea as to why she was contacting me. Mayor Hoy and I had been, our relationship, I would consider it more antagonistic. It had been like that for a couple of years. But I thought maybe now that she was mayor, she wanted to maybe have a new start for our relationship. Anyway, she started the conversation asking me questions about the leadership audit report, not the city manager. And again, this report was done, the finance committee wanted it done to see if we could find efficiencies in the city manager's office. And we chose that office because it was a smaller office than the other offices. We were obviously addressing a revenue shortage, and that was part of the reason that we had started these audits. So it wasn't a performance audit, it was more of an administration. So initially the phone call discussion between the mayor and I was more about process than outcomes. She started linking the deficiencies mentioned in the report, like XX program being understaffed, directly to the city manager. For example, Isn't that his responsibility though? And then a bit later, she asked me about whether I believe the city manager should be terminated or let go. I don't remember the exact words, but that was the tone. And that's when I said that while the preliminary information in the administration and operation of the city manager's office was concerning, it warranted further investigation rather than a disciplinary action. I told her that there was a process that needed to be followed if she was unhappy with Mr. Staley's performance. We never had a conversation where a decision was considered or made regarding the city manager's employment. She asked for my opinion on the outcome of the report, and in my opinion is what I provided to her. Lastly, during the phone call, Mayor Hoy never mentioned that she had or had planned to talk to anyone else. So when she and I talked on February 2nd, I was not aware that I was participating in a serial meeting. Before I go on, just for context, I wanted to fill in some gaps between then and the actual executive session. On Thursday, February 6th, Dan Atchison sent an email to all councilors saying, I understand there's a considerable confusion and consternation regarding what constitutes a serial meeting among the public officials statewide, caused in part by OGEC's guidance concerning serial meetings. He said he was creating a memo, but in the meantime, and I quote, please remember that less than a quorum of councilors, 5 is a quorum, may meet either in person, electronically, or via a series of emails and discuss city business. So that was that email on the 6th. On the 7th, we received another email from him. He was pretty much communicating to all the councilors. And that email started out, Councilor Nishioka informed City Manager Staley that she believes a consensus of council has indicated that they would support a change of the city manager and discussed his potential resignation. Then the Sunday, February 9th, he sent another email out and said, Mayor and Council, attached, please find Mr. Staley's resignation letter. On Monday, February 10th, I did communicate with Councilors Nishioka, Matthews, and Nordyke prior to the executive session. Then we had the City Council meeting where we accepted Mr. Staley's resignation. My time's out, but okay.
Oh, please proceed to a conclusion if you allow me to say it that way.
Thank you. After that, I assumed that the decision to accept Keith's resignation had been made by council because we'd accepted his letter. So it would be okay if we talked about the resignation and what had occurred prior to his resignation. If my interpretation was not correct, then I did participate in a serial meeting at that time because I reached out to or answered calls from other councilors over the next couple of days. The intent of my messages at that point was to gather information to be able to explain what had happened to my constituents who were asking, which is also why I submitted my public statement on February the 14th. Looking back on the whole incident, I'm dumbfounded because at the time of the phone call originally, it never dawned on me that a council member would try to get rid of the city manager in the middle of a critical budget development process for a municipality facing a severe budget deficit. Firing the city manager was not on my mind at all. This has been a huge learning exercise for me. I understand the reason for public meetings laws and the necessity for public officials to not make decisions in the dark. I also understand how fragile public trust is. And I accept that according to the interpretation in the investigation, I did violate public meeting laws, but I did not do it knowingly or intentionally.
Thank you, Ms. Varney. Any quick questions for Ms. Varney before we head to one last respondent? Seeing no hands, Dr. Urban Brown, are you online in Teams? Mr. Brown, Dr. Brown, pardon me, are you there?
Yes, Mr. Chair, I'm here.
Please identify yourself for the record and make any comments you choose to make in the moments we have left for this consideration. Thank you.
Yes, greetings, everyone. Dr. Urban Brown here, City Councilor, Ward 5. My statement is going to be short. In regards to the investigation by Mr. Sullivan, I do realize that he is in a difficult position, and so out of respect for him, I do not have issues with the investigation. My concern itself is how the rules have been interpreted. And my fellow colleagues have said everything that I do agree with. I do not think for a second that any of us willingly and knowingly participated in a conversation to have the former city manager resign. Having said that, several of my colleagues have already stated that we have been working diligently to have a community of trust, collaboration, and just working together as a team. That is something that Madam Mayor has set out from the beginning. And I believe that each of us have been trying to live in that and lean in that every single day that we carry this role as a city councilor. So having said that, there's nothing more I need to say. Thank you.
Thank you, Dr. Brown. Mr. Matthews, I understand you may be online in some way. Are you here? Can you hear me speak?
Yeah, I'm here. Are you able to hear me?
Yes. Do you have anything to say for the record as we near conclusion for this consideration? We're going to move to a Q&A period fairly quickly, but since you're with us, please proceed and hold your remarks to as short a time as possible. Thank you for being here.
Yeah, absolutely. And my remarks have been super short, but and honestly, I don't have anything to say in regards to my case, but I will make a statement in support of my fellow counselors and my mayor. And in truth, I'm not an attorney. I mean, heck, I'm not even really that smart, but I do see myself as someone that just kind of has general common sense. And it really seems clear that all the volunteers in this cases, they were all following the process and the advice of the city attorney. And none of us should be found to have violated any public meetings law with regards to that. So that's my statement.
Thank you. Appreciate it. Okay, colleagues, we've heard from a number of the representatives of the city of Salem. Now's the time for us to engage in a general question and answer session with anybody you choose to ask a question of, including our investigator, our executive, our legal counsel. If you ask me a question, I won't know the answer, so I'll defer that to our executive. Now's the time for questions and answers to help us head toward a decision here. I'm looking to see if anybody has a question or comment to make. Mr. Thompson, please.
This may be a question for Mr. Sullivan, or he can defer it, or just tell me to go away. Either way, but so we've heard from the mayor that she didn't ask votes, and we've heard from the city councilors that they weren't asked for votes. So I'm wondering, which I'm struggling with, what evidence is in the record that those two statements are not accurate.
I think the confusion here is not necessarily that we're not saying that the mayor called every counselor and asked for votes from each one of them, but the conversations were part of the decision-making process of what is her opinion, or what are the issues that we're facing? What are the possible solutions to these issues? And these are all things within the city's jurisdiction. And so I don't have any information that she called and said, what are you going to vote on, or what's your opinion on the matter necessarily, but more raising these issues that need to be addressed by the city and constituting deliberations, those conversations.
All of them?
No, I'm good. Thank you.
I've got a couple of questions. I don't want to get ahead of my colleagues if there are questions, so I will yield if there are some. Couple of questions in no particular order. Executive, Investigator Sullivan, Legal Counsel, can you define for us help us define the definition of the word deliberation as we're facing it? Can you provide that definition? Because we have heard along the way, I forget from whom, perhaps Ms. Gibson, that the word deliberation required statements of opinion from those public officials who could have been involved in this kind of issue. Deliberation is a term that needs to be defined. Help me, please.
Yes, and I wanted to address that. So prior, when Handy was decided, the public meetings law did not have a definition of what counts as deliberation. However, when House Bill 2805 went into effect, it amended 192610.
And 2805 was passed in 2023. Thank you. Go ahead.
And it added a definition of deliberation to the public meetings law. And that definition is deliberation means discussion or communication that is part of a decision-making process. When the commission then adopted administrative rules in October of 2024, October 1st, 2024, we included rules on trying to clarify for everyone what counts as part of the decision-making process. So in the administrative rules, it says a decision-making process is the process by which a governing body engages in to make a decision, such as 1, identifying or selecting the nature of the decision to be made, 2, gathering information relating to the decision to be made, 3, identifying and assessing alternatives, and 4, weighing information, and then 5, making a decision. So everything leading to making the decision is part of deliberations. It is not limited to simply expressing an opinion.
I suspected that from my non-attorney point of view, but thank you for that clarification. Let me ask you a second question, either for you or our legal counsel. Can you summarize for all of us, especially me, the status of the Handy case?
So there's 2 Handy cases, but so there's the Court of Appeals case, which is what most people refer to as Handy.
The Handy case.
The Handy case, Handy v. Lane County. That Court of Appeals case went to the Oregon Supreme Court. The Oregon Supreme Court affirmed part of it and reversed part of it. The majority of that Handy Court of Appeals case that we rely on for all these serial discussions was not part of the affirmance. And so it's that Handy case, the Court of Appeals case, is persuasive authority, but it's not binding authority. And then subsequently, as the executive director mentioned, the legislature amended through 2805 many of the provisions that are before you now. And so some of those prior decisions are no longer relevant because the definitions are now defined in statute.
In actual
versus through.
So it would be fair, would it be fair to say that the Handy case is not law?
Yes.
And
the Handy case being the Court of Appeals case.
The Court of Appeals case, I appreciate that distinction. Thank you for making it. You've used the word to us a moment ago, persuasive. Define what persuasive means to a non-attorney, me.
Right. So there's a portion of the Handy opinion that went through and analyzed some of the public meetings law provisions. Those pieces, because they're not, because the Oregon Supreme Court didn't decide on those and didn't affirm those, it gives us an idea of what the Court of Appeals may think the law is if it went in a similar circumstance. But again, that was the law in 2016.
Right.
So we have the law now after 2023. And so we're interpreting, it's not to say it's vastly different, but you're interpreting a different portion of the law than it existed when Handy was originally decided in 2016.
Thank you. I appreciate that distinction. And one last question that's doesn't necessarily follow directly, but in our process of considering issues such as that before us, tell me how the word intent plays into pardon me for using the word deliberations, play into our process of considering what to do in this case. Does the issue of intent matter to us under law?
So as the investigator pointed out, the elements, there are 2 elements under 192.630. So there's the one under subsection 1 and the one under subsection 2. And none of those elements have any type of express intent requirement in them in order to find a violation. They went you already went through, I won't go through the elements, but you have to find each one of those elements.
Yes.
Present. And then for each individual, you have to find that that individual was part of that quorum that did that satisfied all those.
Thank you. Appreciate it, Council. Vice Chair, please.
You're muted.
Commissioner Payne, you're muted.
I just want to say that Commissioner McCauley had her hand up before me, so I'll wait my turn.
I apologize. Commissioner McCauley, please, your turn, then Vice Chair.
Oh, thank you. Thanks, Chair Fiska. Just really quickly, we heard Mayor Hoy say, and I believe several others, that they relied on guidance from the city attorney. How does this impact or affect this, or should it be considered?
Executive?
Yes, so in administrative rules for the penalty matrix, if a public official is relying on the guidance, especially in the public meetings law, if they are relying on the guidance of their legal counsel, it plays into what sort of penalty versus a letter of ed they would get. At most, they could get a letter of ed. We could not impose a civil penalty. Realistically, in this case, I think it would be regardless of whether they were relying on counsel's advice at the time. These are difficult topics. Please, everyone recognize we know this is not easy. And I think at most we will recommend, should this be made preliminary findings violation, we would recommend a stip for a letter of ed.
Commissioner McCauley, any other follow-up, please?
No, thank you for that. That's
Thank
it
you,
for
and
now. Thanks.
Sorry, I didn't recognize you earlier. Vice Chair, please.
Thank you, Chair. I just wanted to also clarify sort of the timing of some of these conversations, because I think to Ms. Nordike's comment, she had suggested perhaps that we would only be considering conversations prior to the city manager's resignation. But I'm looking at things in the record here that occurred up to the actual public meeting where the resignation was accepted. And I think that's the correct timeline, that we would be looking at all conversations that occurred prior to when the city council accepted the resignation and made that decision in a public meeting. Is that correct?
So, one, all of those text messages and calls. So we have calls from the mayor to the individual councilors the week of February 1 to 6. We have Mr. Staley submitting his resignation letter on the 9th. And then they're having an executive session, I believe, on the 10th. We included all the calls and text messages afterwards, because as much as you are describing them as we were just checking to see how everyone felt, there were additional deliberations. Like it appears there were discussions about, well, maybe instead of accepting his resignation letter, we should instead put him on administrative leave and hold an investigation. That is all part of the how do we want to deal, the deliberations on how should we deal with this situation.
Right. And to me, those almost seem more compelling, because it wasn't just, Mayor Hoy's calls to individuals. I mean, it seems like after the city manager resigns, there's a flurry of sort of texts back and forth as to how they should deal with his resignation. And all of those are happening with each other. And there's conversations about, maybe we should place him on administrative leave. Maybe we should conduct an investigation. What's going on? And, you know, I don't support this decision. Those conversations to me seem very clearly deliberation about his resignation, and they're done in private. And those happen before any executive session or public meeting that takes place, and outside of a public meeting. And those are a little bit more concerning to me, regarding the deliberating of a matter that should be held in public.
Thank you, Vice Chair. Commissioner Help, thank you for returning to our agenda today. Please proceed.
Thank you, Chair. My question is, I'd like to know what is legal for a mayor to talk about on a phone call with their other councilor members. Because I'm a little confused on, I just want to know the ground that is legal. What would be legal for a mayor to call and talk about? Thank you.
Executive Legal Counsel, please.
So 192690 says 3 things that are exempt from the public meetings law. Okay, things that are not within their jurisdiction.
Do you want me to get?
Yeah,
I can read.
Substantive scheduling.
What's the second one?
Educational.
So you have purely factual or educational in nature and that convey no deliberation or decision on any matter that might reasonably come before the governing body, not related to any matter that at the time could reasonably be foreseen to come before the governing body for deliberation and decision, or non-substantive nature such as communication relating to scheduling, leaves of absence, and similar matters.
And you're reading from existing Oregon law.
I'm reading from 192-690, 1M.
Thank you. Did you get that, Commissioner Help? You get that citation? Do you want to look at it yourself?
Yeah, it got a little garbled. I got factual information, calendar information, non-substantive.
Give her the citation again, let her read it for herself.
Yeah. So the citation is ORS 192.690. And then you'll want to look under subsection 1 and then subsection M.
M is in Mary.
For the commission's clarification, that entire subsection was added to the public meetings law in 2023. It's part of House Bill 2805.
Thank you. Good citation. Okay, probably thank you, Commissioner Health. Anything else? Okay, other commissioners, any comments or questions as we move toward a decision in these matters, plural? I'm looking for someone who may be willing to either make a comment or make a motion. Vice Chair, are you willing?
I am willing to make a motion.
Please do so.
I move that the commission find there is sufficient evidence that Julie Hoy may have violated, sorry, I'm going back and forth here. ORS, sorry, I don't think that's the right motion, sorry. I move that the commission find there is sufficient evidence that Julie Hoy has violated ORS 192.630 subsection 1, ORS 192.630 subsection 2, ORS 192.640 subsection 1, 192.650 subsection 1, OAR 199.050.0020 subsections 1 and 2, OAR 199.050.0015 subsection 4, and that the commission adopt the investigation report as its preliminary findings in order that this case move to a contested case proceeding or a negotiated settlement entered.
Thank you, colleagues. You've heard the motion. I'm open to comments on the motion from any of my colleagues who would choose to make comments. Any comments on the motion before we vote? I guess I would say that I understand and expected that motion. This is going to be small consolation to those affected by it, but this has been a very tough issue for all of us on our side, not to mention your side of the ledger as we deal with this issue. If there's a benefit to this process, as some have said, it's that we all are becoming educated about this. I've been around government for 40 years, so this still, not totally, but aspects of it are relatively new law for all of us to interpret. And the good news is that we may both have been educated, and our executive has suggested that the outcome of this, from our vantage point, is likely to be a letter of education as opposed to something more strenuous than that, as we all go through the learning process. So I'm prepared to vote yes. Other comments?
Sure.
Please, Commissioner.
I think for me, it's the change in the definition of deliberation. Under the, I'll say handy decision, and you lawyers smarter than me can figure out which one I'm talking about. But I think under the handy decision, the first one, this wasn't a violation, but under the HB 2805 from 2023, I think the definition changed, and unfortunately, this is.
Thank you. I agree with, I associate myself with your comment, Commissioner. Any other comments from colleagues? Okay, for the moment, hearing and seeing none, the administrator will call the roll on item number 12. Please call the roll at this moment. Thank you. This is only on 12, by the way. We'll go down this sequentially in the order for the city of Salem, but this is item 12 involving Mayor Julie Hoy. Please proceed.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Commissioner Halt is abstaining. Chair Fiscum.
Aye.
Motion passed 6-0 with 1 abstention.
Thank you, colleagues, for a good discussion. I'll leave it at that modifier. We'll now move to item 13. I believe that no further discussion is necessary. Vice Chair, please, item 13.
I move the commission find there is sufficient evidence that Paul Teagan has violated ORS 192630 subsection 1, ORS 192630 subsection 2, ORS 192640 subsection 1, 192650 subsection 1, OAR 199050002 subsections 1 and 2, and OAR 19905000015 subsection 4, and that the commission adopt the investigation report as its preliminary findings and order this case moved to a contested case proceeding or a negotiated settlement entered.
Thank you, Vice Chair. You've heard the motion. Item 13, the administrator will call the roll. Please proceed.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner McCauley.
Aye.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Commissioner Halt is abstaining. Chair Fiscum.
Aye.
Motion passed 6-0 with 1 abstention.
Okay, colleagues, we'll turn now to item 14 involving Linda Nishioka. Vice Chair, please.
I move the commission find that there is sufficient evidence Linda Nishioka has violated ORS 192630 subsections 1 and 2, ORS 192640 subsection 1, 192650 subsection 1, OAR 19905000020 subsections 1 and 2, OAR 19905000015 subsection 4, and that the commission adopt the investigation report as its preliminary findings and order this case moved to a contested case proceeding or a negotiated settlement entered.
Colleagues, you've heard the motion on item 14. The administrator will call the roll. Please proceed.
Commissioner Mettler.
Aye.
Commissioner Halt is abstaining. Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Payne.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscom.
Aye.
Motion passed
Thank you.
6-0 with one abstention.
Thank you, colleagues. We'll now move to item 16. Vice Chair, please.
Chair, I think we're on 15.
Pardon me, item 15. I apologize. We are on item 15. Please proceed.
I move the commission find there is sufficient evidence that Deanna Gwynn has violated ORS 192630 subsections 1 and 2, ORS 192640 subsection 1, 192650 subsection 1, OAR 19905000020 subsections 1 and 2, OAR 19905000015 subsection 4, and that the commission adopt the investigation report as its preliminary findings and order this case moved to a contested case proceeding or a negotiated settlement entered.
Thank you, Vice Chair. And to clarify, that was item 15, my mistake earlier. The administrator will call the roll, item 15.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Commissioner Halt is abstaining. Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0 with one abstention.
Okay, colleagues, item number 16. Vice Chair, please.
I move the commission find there is sufficient evidence that Vanessa Nordyke has violated ORS 192630 subsections 1 and 2, ORS 192640 subsection 1, 192650 subsection 1, OAR 19905000020 subsections 1 and 2, OAR 19905000015 subsection 4, and that the commission adopt the investigation report as its preliminary findings and order this case moved to a contested case proceeding or a negotiated settlement entered.
Thank you. The administrator will call the roll now on item 16, please.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Commissioner Halt is abstaining. Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0 with one abstention.
Okay, turning now to item 17. Vice Chair, please.
For agenda item 17 on the public agenda, I move the commission dismiss the complaint against Shane Matthews.
No, we're on 17, Vice Chair, not 18. 17
Sorry.
first, please. No
Sorry.
problem.
My fault.
No problem.
My fault. All right, 17. I move the commission find there is sufficient evidence that Mickey Varney has violated ORS 192630 subsections 1 and 2, ORS 192640 subsection 1, 192650 subsection 1, OAR 19905000020 subsection 1 and 2, OAR 19905000015 subsection 4, and that the commission adopt the investigation report as its preliminary findings and order this case moved to a contested case proceeding or a negotiated settlement entered.
Thank you. The administrator will call the roll. Item 17.
Commissioner Mettler.
Aye.
Commissioner Halt is abstaining. Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0 with one abstention.
Colleagues, moving to item number 18. Vice Chair, please.
For agenda item 18 on the public agenda, I move the commission dismiss the complaint against Shane Matthews.
Colleagues, you've heard the motion. The administrator will call the roll. Item 1-8, please.
Commissioner Burke.
Aye.
Commissioner McCauley.
Aye.
Commissioner Halt is abstaining. Commissioner Mettler.
Aye.
Commissioner Payne.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Colleagues,
one
number
abstention.
9. Thank you very much. Sorry to interrupt you. Colleagues, number 19, Vice Chair, please.
For agenda item 19 on the public agenda, I move the commission dismiss the complaint against Irvin Brown.
You've heard the motion. Administrator will call the roll. Item 19.
Commissioner Halt is abstaining. Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0 with one abstention.
Thank you, colleagues. That concludes the City of Salem matters before us today. My comment to those who have appeared before us in person or online is that you've heard the words in the motion that are important. In my commentary, they would be negotiated settlement. What we're heading toward, I predict, is a negotiated settlement with you that could result, without prejudging the outcome formally, in a letter of education. I was genuine. I meant genuinely what I said earlier, that this has been an educational experience for both of us, and we've learned from it. We hope you've learned from it, and thank you for being here today and for your patience with our long agenda. Have a nice weekend. You're welcome to sit with us and watch a few remaining items if you choose to do so if you're online, but thank you for being here.
Thank you very much.
Thanks.
Okay, executive, since we're in public session, do you want to proceed through the rest of the items, or do you want to hold them off till next meeting?
No, we do.
What's that no? That's to which question? Okay, we're on item number 4.
Well, why don't we complete the 2 investigations that are
I'm sorry.
remaining?
Number 20 and 21. Okay, we'll forge ahead, colleagues, at 2:15. Sorry about the delay. We'll now hear involving Mr. Caden Sipe from the city of Umatilla. Our investigator is Daniel Pacheco, who fortunately has just returned. Investigator, please make your report, and the individuals involved.
He's online right now.
Mr. Sipe is online. Mr. Sipe, can you hear me?
Yes, sir, I can.
Thank you very much. We will proceed in our normal way. Thank you for being here. We'll call on you in just a moment. First of all, the investigative report from Mr. Pacheco. You're somewhere, colleagues.
Hey, time out.
We're having a technology pause again.
I think it's coming through.
Okay, good.
Coming through what?
Mr. Sipe, we're getting an echo from your camera. Is there a way you could maybe lower your volume or
Mute.
mute until you speak?
Perhaps you can mute until you can speak, Mr. Sipe. Thank you for your patience with that technology bit. Investigator Pacheco, please proceed on item number 20.
Thank you, Chair Fiscum and Commissioners. There's Investigator Daniel Pacheco for the record. Agenda item 20 in your meeting book is an investigation report for Caden Sipe, Mayor for the City of Umatilla. The investigation in this case was limited to whether there is a preponderance of evidence to indicate whether Mr. Sipe and the council failed to properly record the votes of each member by name and provide a true reflection of the matters discussed at the October 15, 2024 meeting and executive sessions. Based on the October 15th meeting materials, Mr. Sipe was present during the regular portion of the meeting, but left before the council convened the executive sessions. In this case, the written minutes only provided the members' motions, the number of votes cast, and whether a motion carried. Because the votes of each member were not recorded by name, either in the minutes or on the recording, Mr. Sipe violated ORS 192.650 sub 1. Additionally, the council did not take minutes of the executive sessions, but instead made a video recording. In this case, the recording of the executive sessions was incomplete due to garbled audio and extended periods of silence. Because the recording did not provide a true reflection of the matters discussed at the meeting and the views of the participants, Mr. Sipe violated ORS 192.650 subsection 2. During the investigation phase, Mr. Sipe indicated that he has attempted to prove meeting procedures and minutes. However, these attempts do not absolve him from his legal responsibilities pursuant to public meetings law. Because public meetings law applies individually to each member of the governing body of a public body, and Mr. Sipe, as mayor, is a member of the governing body, he is individually responsible for any violations that arose at the October 15th meeting. Lastly, commission staff note that 2 of the stipulated final orders that are part of the consent calendar are also related to this matter, and the respondents in those cases will be receiving a letter of education, which has also been proposed to Mr. Sipe. Based on the information available in this investigation report, there's a preponderance of evidence to establish that Mr. Sipe violated public meetings law. The commission should make a preliminary finding of one violation of ORS 192.650 sub 1 and ORS 192.650 sub 2, and order that this case move to a contested case proceeding or that a negotiated settlement be entered. Thank you.
Any questions? Thank you, investigator. Any questions for our investigator from colleagues? At the moment, hearing and seeing none, Mr. Sipe, thank you for your patience with us today in our schedule. Oh, pardon me, Commissioner Health, please.
I just have a question because in a previous discussion, we talked about how everyone was liable for communication on the council or school boards. Is that not the case of the same as the other conversation that we discussed? Because it sounds like now one person is liable for making sure the communications are done, or is it all members?
Thank you for the question, Commissioner Health. So just to clarify, this is just specifically for Kaden Sipe. So this is just the case that we're considering, not the other cases for the other council members. But that is something that we will address at a later time. I hope that makes sense.
Each of the counselors had an individual case. Some have already agreed to settle, some are still negotiating. Mr. Sipe decided not to negotiate and instead wanted us to present the report.
Does that help, Commissioner Health? It's all in
Yes.
the quick answer is it's all in process relative to your question. It's not one person who's going to be held responsible for the entire thing. So thank you for your question. Please
Okay.
proceed. Well, please
Thank you.
follow up if you want. Thank you for your question. Mr.
I'm good, thank you.
Please. Okay, thank you. Mr. Sipe, thank you for being here today. Please proceed to make any comments you choose to make to us, and I'll ask you to be brief and to the point, but thank you for being here.
Thank you, Chair and Commissioners. I am here today to demonstrate the impossible situation that I face as an elected official with no power. I am the elected mayor in a city manager form of government, and the city of Umatilla structures delegates all executive and administrative authority to the city manager and the council as a whole. My role is ceremonial. As the presiding officer, my legislative power is non-existent. Our charter dictates that as the mayor, I have no vote except to break a tie. To date, there have been no tie votes during my entire term, which began in January of 2023. I have no direct authority over staff, and I have zero ability to personally ensure that the city recorder correctly records votes or that the audio equipment functions properly. The OAGC findings hold me individually accountable for 2 violations regarding minutes. I have shown multiple pieces of evidence to show my earnest yet aggressively thwarted efforts to prevent these violations. Even though I have no power over them, the violations are a result of a systemic, administrative, and council deficiencies, not my individual inactions. When I've attempted to address administrative issues that I'm now being penalized for, I was met with immediate, decisive, and written resistance from the city manager. You are currently sanctioning me for minute issues that I have requested to be fixed in January of 2023 when I began. Instead, City Manager Stockdale doubled down and insisted that he make it crystal clear, end quote, that I understood the city was following all ORS 192650 requirements. He went on to remind me that I have no authority over him, nor other staff, and emphasized my role as minimal and without power. He informed me only the council could make changes to minute procedures. Follow-up emails to my questions and requests for an agenda items resulted in responses like, quote, you mentioned you will be pre-approving the agenda with Nancy and I on Thursday. This isn't how your adopted council policies and procedures work either, end quote. Quote, your attempt to direct me without consent of the council is inappropriate, end quote. And when I simply asked to change the order of items on the agenda to match recommendations, I was told in writing, quote, stating that we'll have to be sure we switch the order is a directive, and I understand what I understand to be a violation of city policy and likely our charter, end quote. Even in his attacks on my competency, the city manager highlights the core problem. Quote, this is an atrocious comment and one in which I believe you owe the entire council an apology. You literally have no idea what you're talking about. And frankly, I have no idea where such a comment would have come from. And you are going to explain yourself to the council and to the community, end quote. This response confirms that I operate in an environment where my right to question or seek compliance is seen as an atrocity for which I owe an entire council and the community an apology. You may think that as mayor, I have at least some oversight over the city manager. However, that would be incorrect. I have been told not to participate in the evaluation of the city manager. I have been not allowed to submit a rating of his performance as a part of his annual evaluation. I cannot simultaneously be a non-voting, non-executive mayor who is prohibited from directing staff and placing items on the agenda and be personally responsible for staff's failures to maintain a clear recording or accurate recording of votes. City staff are also public officials within the OAGC's jurisdiction. It seems odd to me that I am accountable as a volunteer for people I do not supervise. For errors of the paid staff, I am the reporter of this complaint, yet I was added as a responsible person. Why weren't the paid staff responsible for their own conduct or for the conduct of those who they supervise added? I am requesting that the OAGC clarify for the public record what specific actions different from the ones that were blocked was I, as a non-voting mayor, legally required to make to ensure compliance with ORS 192-650 to absolve myself of individual liability for the administrative failures of the city of Umatilla. Thank you again for your time.
Thank you. Any questions for our respondent, Mr. Seid? Colleagues, how would you like to, the other discussion for us then is based on what we've heard and read and heard. How would you like to proceed today? Comments on proceeding? Mr. Health, are your hand up again? If it is, fine. Make your comment,
Yes.
please. Please
Thank you,
proceed.
Chair. So when we are holding people accountable for the elected officials, who is in charge of the recording? I think this is a really, who owns the recording equipment, who records it, who posts it? I think that's a really important thing for us to consider on how is this elected person supposed to make sure that this gets posted? Is that part of how does that fall into the ORSs?
Right. I would love it if we could hold the public body responsible or the governing body as a complete entity and not the individual members responsible. That is outside our powers. What the law says is that the governing body, meaning its individual members, are all responsible for making sure each step of compliance with the public meetings law happens. Now, you and I and everyone else knows in many cases that may not be a job that the governing body does itself. Like, when we post our meeting minutes or notices or agendas or videos, it's not our commissioners who are doing that posting, but you are all individually responsible for making sure that we do it right.
Thank you, Commissioner Health, for your question. Follow up? And if not, that's okay.
Yeah, thank you, Chair. So what what would we ask them to do if the equipment is owned by the government body? It is turned on and off by a staff. It is maintained by a staff, and it's posted by a staff. How do we then, like, how do we get what we need? Because what we want is to have records that are accessible by the public, but how is that by punishing the members for the ethics violation? How does that help get to what we're asking them to do?
Well, as I think was pointed out, we are not trying to punish the individual members here. We're trying to educate them. The other members on the consent agenda have agreed to a stipulated order for a letter of education. We're trying to educate them so that they know they need to make sure that these steps all get taken.
Vice Chair, please.
It appears that Mr. Sipe submitted some evidence that he made or attempted to provide some evidence that he made efforts to address this issue. And in the investigation report, I'm seeing that that evidence was reviewed. And then the report says it does not appear to commission staff that any of the materials provided addressed the proper recording of minutes recording relevant to the October 15th, 2025 regular meeting and executive sessions. And I'm a little uncomfortable with that language. It does not appear. Were those materials, or did they address it or did they not? I feel like in an investigation report at this stage, when the investigation has been concluded, I would like to understand whether those materials addressed the meeting or not whether they appeared or not.
Thank you for the question, Commissioner Payne. Yes, so the materials were reviewed and we did also send them to our DOJ legal counsel. I would just say that the reason we indicated does not appear was because there wasn't really anything that appeared to really relate to to that October 15th meeting. And that's the best way I can really say that.
If I can jump in, Daniel, his emails were from 2023, correct?
I'd have to double check the
I think
exhibit.
Mr. Sipe even referenced it himself in the discussion that when he got to be the mayor, he reached out and asked that the minutes be handled differently, and that was in 2023. So it doesn't relate to the specific meeting at issue here.
That is correct.
And so, I mean, for me, I'm sort of going back to Commissioner Halt's comments. One of our goals is education, but we do hold individual public officials liable if they are not going to, agree to a stipulated order and they're going to proceed to a contested case proceeding and challenge these findings. And I'm just trying to understand exactly the efforts that Mr. Sipe took to fix this issue and make it so that the minutes were handled correctly and how thwarted he was in that process. And does he have to do that every meeting? And does he have to do that for this particular meeting? Or was what his efforts in 2023 insufficient if he tried and they basically said, no, you have no power to do this. And so he just accepted that he had no power to do that. I guess I'm feeling a little torn on that. When he seemed to take some action to try to fix a problem how much does he have to keep going to try to fix the problem? And does he have to do it every meeting such that we hold him in violation for this meeting if he doesn't every single meeting say, I renew my objections to how you're doing this.
Let me ask two more questions for context before you answer the vice chair. One is, how many other City of Salem councilors do we have pending before us who haven't agreed to settle?
City of Umatilla.
Pardon me, said Umatilla, pardon me, whatever I said, I apologize.
So we have right now, two individuals, we have three signed SIPs. Two are on the agenda for today, and the rest are just pending signatures. So pretty much all of them have agreed.
Okay, but my question is, that may answer the question, because we probably don't have the authority to do this, but in light of the comments from Mr. Sipe today, what I would like to do is have the others who are involved and haven't settled appear before us as well, so we have more context rather than, no offense to his comments, just his comments, what other people say, because he's alleging some facts, and it would be easier for me to have more context from his colleagues, but maybe they're all settling, so, and maybe irrelevant, Chair. I mean, Director.
Right, they are all settling, and we can't simply hold this one over because we're reaching the end of the 180 days, and he has not time waived the case. So
Well, I was going to ask if you
he
would.
needs to decide in his individual case whether to dismiss or to make a finding of violation.
You answered my last question. He hasn't waived time yet. So anyway, back to the vice chair's comments. Please proceed, somebody, to answer her questions. Ms. Fenstermaker.
I'm sorry, I just wanted to add too. So, Mr. Sipe submitted these emails in 2023, right? We've since updated, the law's been updated, the rules have been updated, right? So he may have interjected at some point in time, but the rules have changed on what's required. So I do think that might be relevant.
Thank you. Good comment. Okay, colleagues, any other questions? Vice Chair, any other follow-ups? Just a minute, Mr. Sipe. We'll make sure that our commissioners have answered. Executive, please.
Our legal counsel, learned legal counsel, did just remind me that the commission could take action to extend the commission by 30 days.
I think only if there's 180 days left, I think. Only if it's sufficient. So I don't know what the timeline is.
Yeah. Look up, and I think the next meeting is like 31 days. So I have
But my notion is irrelevant if everybody else there in the city of Umatilla has agreed to settle pending signatures, et cetera, and this is the only one we have left to consider, then we have to make a decision on this case in and of itself with the information we have before us. Anyway, Vice Chair, you had questions that I interrupted. I apologize. Any other comments for the Vice Chair?
I don't think my question was really answered. To me, it wouldn't matter if the law changed in the interim. What matters to me is, if Mr. Sipe, if there's a violation, if we're asking whether he violated it now, but he's saying he has no, is it a defense that he doesn't actually, that he has tried to, that he has made an effort to sort of make his governing body comply, and the governing body has said, no, we're not going to comply because you have no power over us. I mean, does he have to do that at every single meeting, or is it a violation at every single meeting if he doesn't renew that sort of objection? To me, that seems a little excessive, but when they've basically said, no, we're not going to do what you ask us to do.
It's a very difficult, Mr. Sipe, please know, we understand this is a difficult situation that you are in because of how the city charter is set up and everything, and how the other counselors and the manager respond, etc. But Commissioner Payne, I think, yes, arguably, the commission can make its decision, but under the law, he will need to continue the fight, basically, and do each time try to get them to do it in accordance with the law and make his objections on the record. And
okay, we're heading toward a decision here in the next moments. Mr. Sipe has his hand up. Mr. Sipe, please make your comment very brief, because we're heading toward a decision here in just a minute or two. Please proceed.
I would just like to remind the chair and the commissioners that I have no vote. So when they approve these minutes or they've done anything else, I just sit there and I do nothing. I just ask for a motion. I have zero power to infect change or do anything else. And I don't know how to impress that upon you any further. But thank you for your time.
You just did. Thank you. Colleagues, how would you like to proceed? Looking for
Commissioner Halt.
Commissioner Halt. I didn't see your hand. Please proceed.
I understand what we're trying to do. We're trying to make sure that the public gets the information from these meetings. But it seems like we're hammering the wrong nail, because the people that we are educating aren't the people that are in charge of the camera, aren't the people in charge of posting it. And I'm not really sure that it's fair to give anyone ethics education on this committee at all, because they obviously want it posted to the public and it's not being posted to the public. So I'm not sure how as a committee we can do our due diligence to get what we need to get done, which would be making sure the public is notified of these meetings and gets minutes. And so I'm looking for advice on how we can accomplish what our goal is, because I think we're hammering the wrong nail.
Mr. Thompson, please.
I piggyback on what Commissioner Halt just said. I'm leaning toward, I understand the position that Mayor Sipe is in, and the city charter puts him in a tough position. I understand that. On the other side of that same coin, the Oregon statute doesn't change because Umatilla has a different city charter. That said, what I'm leaning toward is voting no on the recommendation here, but also asking Mr. Sipe to ask the commission for an advisory opinion for advisory opinion on how he and other counselors might deal with this situation where they're stuck between, his duties in the city charter and a state law, which is, holds him accountable. So that would be my recommendation to Mr. Sipe, is ask, because my understanding is any person can request an advisory opinion. So you don't need the permission of the city to ask us for that advisory opinion. And I would suggest you do that.
Any comments on Commissioner Thompson's proposal before us, or notions before us, if they're not a proposal, whatever they are? Comments? Can
Thank you. I will happily do that, sir. Thank you.
Commissioner Burke, please.
Yes, I would tend to go along with what was just suggested.
Thank you very much. Mr. Thompson, please make a motion.
Should have been more prepared.
It's a simple motion.
Oh, this okay. The simple motion. I got it. Mr. Chair, I move that agenda item number 20, the case against Caden Sipe, be dismissed.
For the motion, colleagues, any comments on the motion? You understand the second idea that Mr. Thompson has raised, which shall be on the record. Heard the motion, ready for a vote. The administrator will call the roll on item 2-0. The motion is to dismiss with context. Go ahead, Administrator.
Commissioner McCulley.
Aye.
Commissioner Burke.
Aye.
Commissioner Halt is abstaining. Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0 with 1 abstention.
Thank you, Mr. Sipes. Thanks for being with us. We hope you'll follow through as suggested. Thank you for your patience with our agenda today, and have a nice weekend. Next time. Okay, colleagues, let's forge ahead quickly to item 21. If that's okay. Investigator Pacheco, please. Mr. Messet may have indicated he wanted to appear on Teams today. So
Just a moment.
we'll assume he's going to be here in a moment as soon as you tell me.
And for the chair, commission's information, Investigator Pacheco has invited Trainer Ruth Sylvester to do the presentation for him.
On what?
On Mr. Messet's case. That he gets that experience.
Oh, I thought he was just showing us how he delegates.
Mr. Mesa is on the phone and he is, should be able to hear us. He's pushed *6 to unmute.
Mr. Messet, if you can hear me, if you can't, you need to press *6 to unmute as we head toward considering the matter involving you for the Oregon State Board. Mr. Messet, can you hear me?
I can.
Thank you very much. We're going to now proceed to hear the matter involving you on our agenda this afternoon on October 10th. Our investigator, acting investigator Ruth Sylvester will make this report. Please proceed, investigator.
Thank you, Chair Fiscum. Commissioners, this is Acting Investigator Ruth Sylvester for the record. Agenda item 21 in your meeting book is an investigation report for Dax Messett, who is a member of the Oregon State Marine Board. So on April 25th of 2025, the commission voted to move this matter to investigation to determine if Mr. Messett had violated provisions in Oregon Revised Statute Chapter 244. And in the preliminary review report, it appeared that Mr. Messett had failed to declare a conflict of interest at a January 23, 2025 Marine Board meeting and used his position when he voted to adopt rules restricting certain power boats from operating on the Upper Rogue River, a place where he also conducts his business. The information reviewed by commission staff during the investigation phase indicates that there was no financial impact on Mr. Messett or his business. Therefore, he was not required to declare a conflict of interest at the January 23rd meeting or prior meetings concerning the Upper Rogue River. And likewise, there was no information to suggest that he used his official position for a financial gain or to avoid a financial detriment. As indicated in the investigation report, the commission should find that there is not a preponderance of evidence to establish that Dax Messett violated the prohibited use of office and conflict of interest provisions in Oregon government ethics law and order that this case be dismissed.
Thank you. You've heard the report, colleagues. Thank you, Ms. Sylvester. Any comments on that? Questions? Hearing and seeing none, Vice Chair, please, a motion on item 22. Oh, pardon me, Mr. Messett, thank you for being here. Do you wish to make any comments to us before we proceed?
No, thank you.
Thank you for being here and for your patience with our agenda today. Vice Chair, please, item 21.
I move that the commission dismiss the complaint against Dax Messett.
Colleagues, you've heard the motion. The administrator will call the roll. Item 21.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Commissioner Helt is abstending. Chair Fiscum.
Aye.
Motion passed 6-0 with one abstention.
Thank you, Mr. Messett, for being here for that quick consideration of your item, which has now been dismissed. Colleagues, we're going to forge ahead just briefly for a few more minutes to complete our agenda. The next step is to consider item number 4, the director.
Approve the minutes.
Oh, pardon me. I forgot that. Yes, we have to approve the minutes from the last meeting that have been distributed to you. This takes a motion. The vice chair is now going to make a motion to approve the minutes of the last meeting.
I move that the commission approve the minutes from the September 12th, 2025 meeting.
Any questions about those minutes, colleagues? As you've read them, hearing and seeing none, the administrator will call the roll, please, on the minutes.
Commissioner Payne.
Abstain.
Thank you. Commissioner Mettler.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0 with 2 abstentions.
Okay, director is number 4.
Number 4 is on the consent agenda.
Can we do that separately from the ones below?
Number 4 is separate from the ones before. This is just consent agenda on the waiver of the filing.
Number 4 has been by Mr. Brian Brust, and you've read the report. Any questions on that for our executive? Hearing and seeing none. Vice Chair, a motion on the consent calendar, one item, Mr. Brian Bruss, number 4 on our calendar.
I move the commission approve the public agenda consent calendar as presented.
Thank you. That pertains to item number 4 and item number 4 alone for the moment. The administrator will call the roll, please, on that consent calendar motion.
Commissioner Mettler.
Aye.
Commissioner Halt is abstaining. Commissioner McCully.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Sorry, was that an aye?
Aye, yes, sorry.
Thank you. Commissioner Payne.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0 with 1 abstention.
Thank you, colleagues. Forging ahead, we have no lobbyist penalty reductions, no lobbyist client penalty reductions, no statement of economic interest penalty reductions. We're now to the consent calendar for stipulated final orders, which does not need a report from anybody other than a motion by us. If you're ready.
Items 5 through 10.
This is items 5 through 10. Does anybody want to pull an item off that consent calendar? Hearing and seeing none, Vice Chair, please, the consent calendar on stipulated final orders.
I move the commission approve the proposed stipulated final orders presented on the consent calendar as the final orders in those cases, and the chairperson be authorized to sign them as such.
Thank you. Administrator will call the roll of the consent calendar on stipulated final orders. Please proceed.
Commissioner Thompson. Commissioner Burke.
Aye.
Commissioner McCully.
Aye.
Commissioner Halt is abstaining. Commissioner Mettler.
Aye.
Commissioner Payne.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0 with 1 abstention.
Okay, colleagues, one last item before we do a couple final things. The stipulated final orders, not consent calendar, dealing with Mr. Jake Huffman from the Cook County School District. He is not going to be online today. The investigator is either Casey Fenstermaker or Lion Gallagher. You may choose who speaks.
That is all Lion. Yes, thank you, Chair Fiscum and Commissioners. This is Investigator Lion Gallagher for the record. Public session agenda item 11 in your meeting books is a stipulated final order for Jake Huffman, principal for Cook County High School. On May 9th, 2025, the commission voted to move this matter to investigation to determine if Jake Huffman had violated provisions in ORS Chapter 244. In the preliminary review report, it appeared Jake Huffman had failed to declare a conflict of interest and used his position when he used district gym facility without a contract or without paying a fee to conduct practice for the Central Oregon Wrestling Academy, LLC, a business with which he owns. During this investigation phase, commission staff were able to verify Jake Huffman's violation of ORS 244.040 subsection 1 and ORS 244.120 subsection 1 sub C, based on district materials and information provided by Jake Huffman and his attorney. Jake Huffman has agreed and indicated he wishes to conclude this matter and has signed the stipulated final order. The order in your meeting books provides that Jake Huffman will pay a civil penalty in the amount of $1,000. We are recommending the commission approve the stipulated final order.
There much questions about from our investigator? Hearing and seeing none. Vice Chair, please, stipulated final order on number 11.
I move the commission. Oh, am I? Okay. I move the commission find there is. Sorry, I'm on the wrong motion. I move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Thank you. You've heard the motion. Minister will call the roll on item 11.
Commissioner Halt is abstaining. Commissioner McCully.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Mettler.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0 with 1 abstention.
Thank you, colleagues. We will now move quickly to final reports from our staff in some way or another. They are first annual key performance measures, executive.
These were completed and have been submitted. Becky, did you have anything you wanted to say on these? Becky did an amazing job with them. Good job, staff.
You can,
There we go.
you can pay her for that later, so.
I know you guys are very short, on that, so I'll leave it at that.
I would encourage you to read the, I would encourage you to read those.
If you have questions, let
Yeah.
us know.
Becky, any comments necessarily? Okay. Trainers report.
This is Stephanie Heffer, the curriculum and training coordinator. I will keep this short and sweet. We are focusing on outreach. We are doing lots of conferences. We've partnered with SDAO. We're going to be, Susan and Casey will be presenting at a Metro breakfast for them. I know I presented at the Oregon Association of Municipal Recorders 2 weeks ago. Also coming up is County Council Association. So yes, very much focused on partnerships. We've also been working with the Legislative Equity Office and getting out information about their trainings, required trainings for lobbyists. And we finalized the Oregon Community College Association's public meetings law training. It has been approved, and there's the letter in your book. And the newsletter did go out, but it went out after the book was completed. So the newsletter will be in your next book.
Thank you. Questions for trainers?
Yes, one more thing, sorry.
Please.
Charlie Esparza,
yeah.
Our trainer who has been with us since 2022. 22, yeah. He accepted a new position as a inspector for the Oregon Veterinary Medical Examining Board. We wish him all the best of luck in that new role. We're very excited for him.
He just couldn't keep up with the training schedule. We can be honest about it.
It's been pretty rigorous, not gonna lie. I think it was more he was ready for Portland versus Salem.
Well, I could argue with that. That's it. Okay, executive director's report, page 318, executive, please.
Commissioner Health has her hand.
Oh, I'm sorry, Commissioner Health, I failed to see your hand. That's my fault. Please proceed.
That's okay. Thank you, Chair. I'm wondering if we are working with OSBA or League of Oregon Cities on some of these repetitive things that we've heard about violations on serial meetings and communications for minutes to make sure that we're getting to the root of the problem to kind of get rid of some of these things that are coming before us before they happen. Thank you.
The quick answer is yes, our executive will cover that related to her report. Please proceed.
So my ED report, you can read what's all there. I hinted at this, but I attended and testified before the House Interim Rules Committee. They wanted to know about food issues, providing meals, that opinion, and serial communications and other public meetings law things. They have formed a working group chaired by Representative Sosa, former commissioner, and he had been the one involved in House Bill 2805 as well. The working groups had one initial meeting. It involves all sorts of people, a bunch of legislators, SDAO, League of Oregon Cities, County Council, Metro, City of Portland. There's a whole lot of people in this group. We are all submitting sort of suggestions, things we'd like to address. So the working group is looking to see, are there any steps or improvements that could be made in a bill in the short session? Cannot guarantee that's going to happen, but the working group is trying. In the meantime, I am still working to do a proposal to the Law Commission to see if they can help get more global reforms made to the public meetings law. So that's all in the works. The last thing I wanted to say is to point out that Casey Fenstermaker attended the Government to Government State Tribal Summit earlier this week. So time flies. I know, I think you saw Commissioner McCauley there.
I did, yes.
And so we are all trying to be very cognizant that with our public meetings law jurisdiction, we are getting more tribal members that may come before us, and we need to be aware of some of the implications and things that raises for us. So that's all I have to say.
Good comment. Okay, colleagues, heading toward 3 o'clock. Thank you all for your patience with a long but productive agenda today. In my humble judgment, we're going to stand adjourned in a moment pending our next meeting on November 14th. So thank you for Commissioner Halt. By your next meeting, you have to vote. Don't forget. Colleagues, have a nice weekend. We now stand adjourned. Thank you.
Thanks, everybody. We'll see ya.
Take
Thank
care,
you.
everyone. Keep them flying.
I knew when I looked between